We've got breaking news. Donald Trump filing a motion less than an hour ago asking a judge to delay his hush money trial until after the Supreme Court decides on his claims of presidential immunity. Lisa Rubin is an MSNBC legal correspondent. She joins me now. Can you help us understand how the hush money case has anything to do with the immunity case?
Well, Chris, I'm going to do my very best to at least explain to you how Donald Trump believes it has to do with immunity. Donald Trump's been charged with 34 felony counts of falsification of business records. Those business records relate to the reimbursement of Michael Cohen for the hush money payments to Stormy Daniels in the fall of 2016. However, Cohen was not repaid, and the invoices and checks and false records were not created until 2017, when, as you know, Donald Trump was serving as president. He says those should be considered as official acts because, but for his being president, he would have never had to hire Michael Cohen as his personal counsel. If that sounds tortured to you, it has also sounded tortured to a federal judge who, when Trump tried to remove the hush money case to federal court last spring, said that Trump's immunity argument was not even reasonable or colorable, in part because it was based on the portrayal of facts as I just gave them to you.
So this trial is supposed to get going 2 weeks from today. What are the chances a judge agrees to the delay?
I don't think very high. I think Trump has already waived this argument. He raised it in front of Judge Hellerstein last June when he was trying to remove the case, because federal removal of a case against a federal officer requires not only that the person be a federal officer, but that you identify a federal legal question, here a federal defense that you would raise. Judge Hellerstein said that the immunity defense at that time was not colorable. Trump did not appeal that judgment. So you can expect the Manhattan DA's office to say in the first instance, hey, he's already waived this argument, irrespective of what the Supreme Court finds in the D.C. federal election interference case. Trump had an opportunity to litigate this fully and fairly, and he dropped the issue. But beyond that, they may also argue that his attempt to characterize and cloak this as a matter of presidential immunity is really lost, that this was a personal thing that he did for campaign purposes, and that there's nothing presidential about this, even if the papered over of this occurred in 2017, Chris.